Dear friends, in this video, I am taking the case study. How one can use the chat GPT. DeepSeek also is same like this. But chat GPT is very good, very useful, very fast. As I explained you in my previous video, how to download your chat GPT. And I must have told you that I took 20 days to prepare a petition, rejoinder to the petition. At least 2-3 rejoinders I prepared. And then even the argument, style of argument, the flow of presentation, everything is not correct for me. But today, the same case comes into hand. I may spend time for crux of the subject. It may not, the preparation of the petition or the orders will not take more than 5 minutes, 5 to 10 minutes. How you can use it, Chat GPT? Please remember, Chat GPT is a machine, artificial intelligence. It will work based on the inputs we are giving. So you need to deliberate and discuss with the chat. That's why it's called chat. You are going to keep on what you want. It is like a film director who will make the actors act according to his script. He is expecting this is the scene. And like this, we are going to talk about it. Very, very good. I again tell you, 1 year back, 1.5 years back, 1 year back, my son-in-law told me this is very useful for lawyers. So I wanted to understand. Suddenly somebody said, no, this is waste machine and all. It is not possible for use and all. Then I dropped out. Only last 4 months to 5 months, again accidentally, my son-in-law told me try it. Then I realized you don't need staff. I'm telling you, don't need any staff. And you can execute at least 10 to 20 petitions a day. And you can easily argue perfect plan. That is how this will be very useful to the young lawyers, particularly those who are not having formal qualification. I mean, training in colleges and all. And let us see how you can use. Please refer to my previous videos also. So I have asked the Chat GPT, you please prepare an order like a judge. I am the judge. How an order can be prepared for a judge. Even you find NCLT, NCLT, the judges are burdened with too much of work. Another problem is they have to hear, they have to new changing law, and they will have to pass orders. So normally you have to take the help of a law research associate or now the Chat GPT. But finally they will only dictate, judges. Even if the LRA is very smart, LRA who is asked to prepare, still something may be wrong. And that they have to ensure, judges. And many judges will be scared, something goes wrong in their thing, then they'll go to NCLT and they'll be criticized. Nobody would like, because their order will be tested in the next level up to Supreme Court. And if Supreme Court makes some comments, adverse comments, then nobody will like it, because that you all know that. Now let us see my case. It is a case filed by IDBI Bank for removing me as a liquidator. I was appointed by NCLT adjudicating authority while pronouncing the order for liquidation on 29 May 2020. So along with that order, I was appointed as the liquidator. Then IDBI Bank, actually they are not part of the stakeholders committee, consultation committee, because they have not surrendered the security interest as per section 52. But then IDBI Bank, the problem with IDBI Bank was that they have lent 252 crores to the promoters without any security. Security means forest land. The first they have lent the money, then the promoters gave, okay, you take this forest land. There is no water, but they want to produce sugar cane. And machinery also is not assembled, but they were showing production of sugar. This is the subject. In fact, IDBI Bank only appointed me as the liquidator, as the resolution professional. But when I was checking everything, this data, everything we have to take, and based on the information there, the staff, 1,000 workers were there and all. Then we asked the questions to them that when we have to prepare asset memorandum, therefore, what is these things? This was under the custody of IDB Bank, physical custody. They have taken the factory. So IDB Bank wanted me to give it back to proper promoters. And since we cannot give because as per rules, they became hostile. Liquidation order was pronounced. This is the background to the case. And the case was filed by them. Ultimately, I was removed. When I was removed, when I solved all the problems of the company, and they were willing to give back the company for 100 crores to the promoters, they refused promoters. I won the case in Orissa, and we got value of more than 1,500 crores. So they came, all promoters, IDBI Bank, everybody, and then they influenced the system and got me removed. The adjudicating authority, the technical member, reserved the matter for orders on 20th March 22. After hearing all this, he said Madras High Court stay order is there, and then the problem is solved. Why should the petition cannot be entertained? He reserved for orders. But on 1st July, he removed me, last date of his this thing, because he was terminated. Extension was not given by Supreme Court for some corruption charges. They removed me. Nobody knew. The order was pronounced at the last 4 o'clock. Nobody knew that the order was being pronounced. But it was uploaded on 6th. A new liquidator was appointed who had no experience, just passed the insolvency exam, and he was earlier assisting promoters. So you can see the scheme of things, what happened. And we sincerely worked, all those staff, professionals who worked, helped me solving this in Orissa using all the influence. They were left in lurch. So, suppose, for example, how you will present the case before Nclt. This is the case study. And that is before the judge. That is a genuine judge who would like to pass an order in accordance with law. Whatever I am saying will be useful for appeal, those grounds. But at the time, what you file is very, very important. So I tested this before the ChatGPT, and I have given the inputs like this. What did I say? Please prepare an order under section 16 of General Clauses Act. Please prepare an order under section 16 General Clauses Act. Read with rule 11 of NCLT rules. Before NCLT, the applicant filed these things. Understand? The applicant, IDBI Bank, filed a petition seeking removal of the liquidator, and I am the respondent. You understand? What is their grievance will tell. But then they wanted the judge that you have power under General Clauses Act. Read with rule number 11 NCLT rules. And so he should be removed. I am the liquidator, Venkat Shivkumar. And the final notes of submissions will be there after the arguments. The final notes of submission, IDBI Bank prayer liquidator who was appointed by NCLT as per section 34(4) of the code in June 2010 needs to be removed. This is the prayer. So you can see even the English flow is not correct. Quantumly I have done. So it is summary, like a layman when you are talking. This anybody knows. Whether you know English, Tamil, Telugu. It is a prayer by IDBI Bank to remove the liquidator who was appointed in June 20 under the rule 11 NCLT rules and General Clause Act. You can remove. That is the prayer. The liquidator was appointed as per section 34(4) of the IBC code. That they have not said. But then what they are telling is the liquidator is appointed by NCLT. What is the source of power? 34(4) IBC. They have not said that. Please remove the liquidator. He is wrongly appointed by NCLT. What is the reason? Right. What are the grounds they have taken? Evidence, everything. So much of arguments. Ultimately, it boils down to this. That the liquidator at the time of appointment did not have authorization for AF assignment. He suppressed the fact that he does not have. Therefore, it amounts to cheating. Again, I put it in such a way, there is no link, but then this is the objective. They said he should have an AIFA, but he did not have. Not having and then saying, appoint me is wrong. It is false, suppressed, cheated. Like that, they used very strong words. Summary is this. When he is not having AFA, his appointing order is wrong. 2. What is that they say? We have seen the website of 2 regulators. First regulator is IIIPA, Institute of Chartered Accounts. It says nil. Nil is different from rejection. Third, we have also seen IBBI website which says rejected. Therefore, he violated regulation 7A of IBBI regulations and cheated NCLT. Hence, he should be removed. That was their prayer. Right. IDBI Bank also showed the order of IBBI. So what they did, IDBI Bank, they again filed a complaint to IBBI at IIIPA. In addition to NCLT, NCLT, 4 complaints on same AFA is not there, they filed. IDBI Bank showed the order of IBBI finding the liquidator guilty. So IBBI found me guilty. Right. This is what they showed. They didn't show anything other than this. So, sum and substance of the petition of IDBI is this. The liquidator is not having authorization for assignment. He suppressed this fact, therefore he is not fit to be a liquidator. Then they said, removing, how to remove him? Since you appointed him, the appointing authority can remove it. That is what section 16 General Clause Act says. That is, anybody who is appointing you can be removed. But the problem is, the General Clause Act will come into play when there is no other provision. IBC is a specific code and there is a provision. IBBI, the NCLT appointed using that provision. Actually, this IDBI should have shown they have appointed as per this clause, but it is wrong. In that there is no AFA. Correct. So there is no case made out. But then they have appointed very big lawyers. They pay 5 lakhs per day. And these people, they have done this. All right. So what did this is sum and substance of the case. Now the respondent, what are the issues that was submitted by the liquidator? He filed application. I said, I filed application for grant of AFA on 1/1/20. It was rejected on 16th July. after 7 months. As per bylaw, if the AFA is not granted within 15 days, it is deemed to have been issued. Hence, he did not violate any regulations. So this is the law. As per law, how did you say the 16th July only received? IBBI has said that. Because the petitioner himself was saying he received after 7 months. Then I showed the IBBI approval on the website. So they made a false statement, IDBI Bank, saying that they have not seen when there is approval. So I showed the proof. Then IBBI did not mention rejected. All that they said nil. That means it's still being processed. And I also showed the RTI, which IDBI itself got it in their typed set. So I have clearly established. And then I have shown IDBI Bank is only one of the 7 financial creditor and has no locus standi as they did not relinquish the security interest as per section 52 of the code. So they are not part of the SEC. So they don't have locus standi. And I have also submitted the order passed by the IBBI was stayed by the Honorable Madras High Court. And so when there is interim stay, so where is the question of proceed? They say should not have proceeded in this matter. Now, then I also explained that because I have exposed their illegal acts, they are very angry with me. So therefore, there is a malfide intention. This is my case. So now I presented all this. You can see totally like a layman I have presented. Though law I know. Then I don't know what is the first one, what is the second one, how to argue, which one is very important, locus standi, jurisdiction, etc., and all. And you remember to write this, I took 20 days. So many times we have been writing. Flow is not coming. We don't know. And bad flow of this and writing also. Now, ChatGPT, you see how beautiful it has come. Within 5 minutes, not even 5 minutes, I think 1 minute, they have posted this. You see how they presented the English that we could never imagine. This tribunal is seized of the application filed by the applicant, IDBI Bank Limited, seeking removal of the. This is the order. How NCLT should have passed the order. You see, this tribunal is seized of the application filed by the applicant, IDBI Bank Limited, seeking removal of the respondent, Mr. Venkat Shivakumar, from the position of liquidator under section 34(4) of the IBC code. If you see that this was never discussed in the order, that is the point. So, how can you argue? You are telling them the court is not taking 34(4) of the code. This is where how beautiful flow. The entire, 10 paragraphs has become 1 paragraph. This tribunal is seized of the application filed by the applicant, seeking removal of respondent. So the judges can be rest assured the flow of English is excellent and the points raised are impeccable. Next, applicant submissions. In every findings you have what you said, what they said, what you say, the court says. The applicant contends that, applicant means IDBI Bank contends that the respondent did not possess a valid authorization for assignment, AFA, at the time of his appointment, thereby suppressing material facts and committing an act of misrepresentation. See the flow of that, about 10 paragraphs has become 1 paragraph. The website of Indian Institute of Informal Professional ICA reflected nil, implying that respondent was not authorized for assignment. That is what these fellows are saying. The website of Insolvency Bankruptcy Board of indicated rejected in reference to appellant respondent AFA's application. The respondent's conduct violated Regulation 7A IBBI. In the light of the above, respondent should be removed from the position of the liquidator. So here there is a mistake. No, there is no two more points to be added. Understand what are the two more points? The NCLT can apply section 16 and 11 of rules 276 of Companies Act and remove him. That is what this is missing. So as a thing we have to introduce this point. You understand? The machine will not know. So that means you have to communicate with the machine to ensure that whether the court judge has understood all the points raised. Right? That is what is missing there. 34.4 of the code only is there. If you see the chat GPT above, if you see section G, this point was omitted by them. This is the grounds on which they have removed. Understand? So we have to tell them, no, sorry, this is not correct. So all the points are there. This is the thing. One point they said, applicant submissions, respondent submissions. Respondent opposed the application and contends that he applied for this on 1/1/20. It was rejected on 16th of more than 6 months. As per bylaw 12I5, the bylaws, if an offer is not granted within 15 days, deemed to have been issued. Therefore, he did not violate it. First point. Then B. You see 3AB. So 1, that is what is the issue. You see format, introduction. 2, submissions of the applicant. 3, respondents. He applied for AFA on 1/1/20 and it was rejected. Are they clear? His appointment was duly approved and reflected in the IPBA website relevant time. To mention nil on the IPBA website does not mean rejection, but merely indicates lack of an entry. Further, this point I did not know. That's beautifully explained. Further, RTA response from IPBA in August 20 confirmed that the matter is still pending. So, IDBI Banks lacks locus standing to seek removal as it did not relinquish its security under 52 IBC and it is not a part of stakeholders committee. Reliance is placed on Kiran Shah's Punjab National Bank, where the NCLT held that financial creditors cannot seek removal of a liquidator as their claims are adjudicated by them. The Honorable Madras High Court in writ petition has stayed IBB order finding respondent guilty. Therefore, the finding of guilty cannot be relied upon by the applicant. The present application is motivated by malified intent as liquidator is exposed to fraudulent lending. So beautifully, everything is covered. So if you see, the sum and substance is clear. The chat GPT, it is a machine, artificial intelligence. So you cannot assume everything will come correctly. It all depends on the inputs you are going to give. So what are the inputs you are given? What exactly you want? Because the judges, when this is from the point of judges I am talking, when the judges are thinking about the subject, they would have relied upon certain points. And that certain points only will be the basis for judgment. Then they can get citations, application, and another angle also. Right. Having considered the submission of both parties and the materials on record, the tribunal finds as follows. So the first point they gave importance is 34.4. 3.4, this is misconduct, incapacity, conflict of interest, lack of independence. Actually, these are not correct. All these three are wrong because 34.4 ABC is different. So you have to tell them, sir, this is not correct. I told them. You see how they changed it. The applicant should have, actually that is the duty of the applicant to show this is the violation, that is this thing. He has not shown. The rejection of the respondent's AFA application occurred after his appointment and bylaws supports contention of AFA is deemed to have been issued if not granted in 30 days. So that point, Kiran Shah, locus standi they approved. 16, you see, they have said, General Clauses Act which states that power to appoint includes the power to remove, as no application in this case, IBA contains specific provision for removal of the liquidated transaction 634. Therefore, general principles removal does not apply. Rule 11, which provides inherent use, cannot be invoked in the present case, as statutory mechanism under 34.4 is there. Honorable Karnataka has held that NCL cannot invoke Indian jurisdiction where IBC provides for specific remedy. Honorable Madras, this I did not know, embassy, then they have provided. Whenever you argue, this is binding on them. You have to seek answers. Honorable Madras High Court stated the IBA, which means that for all practice, the finding of guilt against the respondent cannot be relied upon at this stage. The timing and nature of this application raises concerns, bona fides, particularly in light of allegation that the respondent had exposed fraudulent transactions by IDBI Bank. Conclusion. In view of the foregoing findings, this tribunal holds that IDBI Bank lacks locus standing to seek removal accordingly. What a simplified method, dear friends. Really, this will be very useful for you to argue. Because first you can prepare your rejoinder and you can read out each paragraph of the rejoinder supported by the evidence in the typeset. That's all. Only one typeset, one thing. Sit on this. That's all. You will win the case. But here, I have messed up the whole thing, writing pages and pages. It's 3 years back, and ultimately, the way you argue, you should always stick to Supreme Court, and only one book. That's all. So now I have chatted with that, saying that 34.4a is wrong, etc. You can see now. I have made a comment immediately. Excellent presentation. 34.4 of the code needs reproduction. Glad you liked the presentation. Here the order of 34.4 be reproduced for completeness. See, having considered submissions of the both parties material, tribunal finds as follows. 34.4 insolvency may be these things ABC. It is evident. See, they have revised everything. And they have included all that. So now I ask them to make a further refinement and give me a final paragraph. Now they have prepared the petition. They have prepared the order. And this is what the judges can make use of. Up till this, how judges can use the AI for writing their orders effectively and perfectly. I've asked actually one question to this, saying that what will happen if IDBI Bank, you can see, suppose why don't you give me your opinion from the angle of IDBI Bank. Then they said no, IDBI Bank can only suppress the evidence if the judge wants to give a favorable order to IDBI Bank, then he should be biased and prejudiced. So he will reduce the material information, he will not consider, and then misrepresent the existing information and then pass the order. Exactly the same thing has happened. This we are going to talk. How you can appeal. Whenever you are preparing an appeal, dear friends, we will have to paragraph-wise rejoin. Order will be there, and therefore you have to deal with that. In this case, this is all these points imply the IDBI Bank suppress these things. IDBI Bank's application filed only after exposure of fraud reinforced. Once again, they have presented malified abuse of judicial process, a rule, Nclt rules, everything. And every point they have redrafted it. And you can see this interpretation of the code. This is once again. You can ask number of times, then you will polish it. It is all going to take 2 minutes, not more than 2 minutes, dear friends. So please try this and you will realize you don't need staff, and you can just do 10 to 20 per day. Judges can pass the orders. I have now reached the next video. We have worked on restructuring the NCLT format of filing the petition, format of filing the rejoinder, and format of notes of submissions, so that the judges will be able to rely upon the law research associates and pass an order. So now paragraph wise, this is for appeal. We will take up this bit later. Next thing.